very warm welcome to thorough newspaper analysis for the 29th of March 2024. Now let's quickly head to the agenda for today. So first of all, for the editorial segment, we've taken up an article from Indian Express. The article is titled as When the Supreme Court Stepped In Against Bail Conditions Imposed by Various High Courts. So we're going to have a look at some instances of various high courts which imposed certain bail conditions which did not set well with the Supreme Court, and finding those to be unreasonable, the Supreme Court set aside those bail conditions. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So now let's quickly proceed with the editorial with the title, When the Supreme Court Stepped In Against Bail Conditions Imposed by Various High Courts. Let's quickly see the context. Supreme Court recently ruled that imposition of a bail condition which prevents a person from participating in political activities, it is a violation of their fundamental rights under the Indian Constitution. Now, why this observation? Who imposed this bail condition and on whom? Let's see. A bench of Justices B.R. Gavai and Sandeep Mehta, they set aside a condition which was set by Orissa High Court in an earlier order for BJP leader Siba Shankar Das. So now let's go to this order of the High Court and see what the case facts are. See, in the case of Siba Shankar Das alias Pintu versus the state of Odisha, the apex court was dealing with a petition filed by BJP leader and former mayor of Brahmapur. He challenged an earlier order of the Orissa High Court. On 18th of Jan, the High Court rejected Das's plea to withdraw a condition which was imposed on him by the High Court in 2022 in August for granting him bail in a criminal case. So see, essentially there was a criminal case against Das. The High Court granted him bail in 2022, but with a condition. This condition was challenged by Das before the High Court again, and he sought that the High Court may please withdraw this bail condition, but the High Court is rejected to do so. Now, we've mentioned that bail condition is being, the plea has been made, but it is rejected. So let's see, what is this bail condition in question? The High Court had said that the appellant shall not create any untoward situation in public, and this is important, shall not be involved in any political activities either directly or indirectly. So this was earlier imposed by the High Court in August of 2022. Then Das approached the High Court again with the plea that you may please kindly withdraw this condition. This plea was rejected, and therefore he is before the Supreme Court. Das argued before the High Court that as a political person who was earlier elected as the mayor, he should be allowed to participate in political activities given the upcoming general elections. Further, the state government contended and contested Das's plea by arguing that after his release on bail, Das had been involved in a new case and a murderous attempt was also made against him where a bomb was hurled onto his vehicle. Additionally, the state government also supplied the court with an affidavit from the local police inspector objecting to Das's plea and citing the registration of 2 new FIRs against him last year in October. So observing that the petitioner is always under life threat, a single judge bench of the High Court said that lifting the condition at this particular point in time, it shall in all probability put the administration to enough difficulties. Challenging this rejection of withdrawal application, now the concerned person Das is before the Supreme Court, and we've already seen Supreme Court. What has the Supreme Court done? It ruled that imposition of this bail condition, it is unconstitutional. It violates the provisions of the Constitution. Now let's see, first of all, how bail and bail conditions work. See, bail essentially refers to the temporary prison release of a person who is awaiting trial or an appeal. It is secured by deposition of a security before a legal authority as a guarantee for his eventual presence in court. So what you're doing, you're depositing certain security as a guarantee that, whenever the court is going to call me and seek my presence, I'm going to mark my presence in compliance with the bail conditions. While exercising its discretion to release a person on bail, the court concerned must ensure that it acts judiciously. The Supreme Court had observed in 2009 case by the name of Khilari versus State of UP. You may make a note of it. It also ruled that the appellate court must record its reasons while granting bail. That is to say, whenever a bail is granted, it has to be followed with a speaking order, as in the order which is granting the bail, it should be a speaking order. It should have reasons recorded for grant of bail. Additionally, Section 439 of the CRPC states that a High Court or a Court of Session can direct any accused person in custody to be released on bail. It also allows these courts to impose any condition that they consider necessary for the purposes of Section 437, Clause 3, which lists conditions that can be imposed in cases of offences which are punishable with 7 years of prison term or more. These include ensuring that the accused does not commit a similar offence, that he does not threaten persons associated with the case. And I'm sure if you've read any bail order, you will see that there are certain standard bail conditions, like that the person cannot travel out of India without informing the authorities, or that, you are not going to tamper with the evidence, you're not going to give any sort of inducement, threat, or promise to any witness who is acquainted with the facts of the case. Why? So as to dissuade the person concerned from disclosing the facts which the court or police may seek, and conditions of the like nature. So now let's see what the Supreme Court said in Das's case, although we have already seen it here, but let's see. On 22nd of March, a division bench of the Supreme Court set aside this order, saying that imposition of this condition, it would breach fundamental rights of the appellant, and no such condition could have been imposed. Thereafter, subsequently, the court said that it was quashing and setting aside the condition. Now, this was one instance where the top court intervened in the bail condition, but a question may arise as to, has there already been other such instances? So the answer here is yes, absolutely yes. Let's see a couple of examples, starting with the example of a condition that was imposed by Andhra Pradesh High Court on Chandrababu Naidu. Let's see. Last year, Andhra Pradesh government challenged a High Court order which granted bail to Telugu Desam Party, TDP chief, and the former chief minister of the state, N. Chandrababu Naidu. On 28th of November 2023, a bench of Justices Bela Trivedi and S.C. Sharma, they sought a response from Naidu, who was accused in Andhra Pradesh Skill Development Corporation scam case. So in doing so, the top court lifted the Andhra Pradesh High Court's directive, which prevented Naidu from taking part in public rallies and meetings as a condition for his release on bail. The Supreme Court stated that the conditions imposed in the bail order, they shall continue except this one condition. What is that? Participation in public rallies and meetings. So this condition was stayed by the Supreme Court. Now let's see example of Rajasthan, Allahabad, and Madhya Pradesh. So in Rajasthan, what happened was, Rajasthan High Court directed the accused to be released on bail, but with the condition of deposition of rupees 1 lakh fine, along with the surety of another lakh, and also 2 further bail bonds of rupees 50,000 each. So what is happening here? The bail amount, we can see it is considerably higher, on the higher side. So that is what the Supreme Court took note of and said that the bench was of Justice Krishna Murari and Justice V. Ramasubramanian. They ruled that the conditions of bail, they cannot be so onerous, they cannot be so, stringent and so on the higher side, that their existence itself tantamounts, it itself is equivalent to a refusal of the bail itself. Further, we come to Allahabad High Court, where a division bench of the Supreme Court of Justice A.M. Khanvilkar and J.V. Pardiwala, they set aside a bail condition that Allahabad High Court imposed, asking to seal Muhammad Ali Zohar University in Rampur while granting bail to Samajwadi Party leader Azam Khan. So here also the Supreme Court said, and I would like to quote, "This is yet another matter where we find that the High Court is referred to matters which are unrelated to the consideration of prayer for bail in reference to the case which is registered against the person concerned." Next example is of MP High Court, and this is very widely reported. So I'm sure a lot of you have already read about it. What happened essentially was there was an accused before the High Court with the bail plea, and he was accused in a case of sexual harassment and sexual assault against a woman. So this was a crime against a woman. Now here, the High Court asked this man who was accused of assault to get a rakhi tied on his wrist by the victim as a precondition to getting bail. So this was a precondition for getting bail. Acting on a plea by an advocate of the Supreme Court and another 8 women challenging the High Court order, the Supreme Court bench, again consisting Justice A.M. Khanvilkar and Ravindra Bhatt, issued directions which are to be followed by lower courts while they are deciding bail petitions, especially in matters of crimes against women. So this was a directive launched by the top court to all the lower courts to keep in mind and consider while they are dealing with bail petitions in matters which involve crimes against women. Here the Supreme Court said that courts should refrain from requiring or permitting contact between the accused and the victim and protect the complainant from further harassment by the accused. The court here said, and I would like to quote, "Bail conditions and orders, they should avoid reflect stereotypical or patriarchal notions about women and their place in society, and it must strictly be in accordance with the requirements of the CRPC or the law concerned." And now we proceed to the next segment.
Now let's start with the national news category, and the first is this update. Mumbai, the financial capital of India, it overtakes Beijing, Asia's billionaires capital, for the first time. Mumbai is now Asian capital with the most number of billionaires, overtaking Beijing according to Huron Research Institute's Global Rich List. This is the first time that India's most populous city, also the financial capital, has taken the top spot in Asia. Topping the 2024 Global Rich List for cities, it is New York with 119 billionaires. This is followed by London with 97. As far as Asia is concerned, Mumbai, India's financial capital, it moved ahead with 92 billionaires, according to Huron. Following close behind Mumbai are Beijing, 91 billionaires, and Shanghai with 87. Next up is an update in the sports category. BCCI, which is the Board of Control for Cricket in India and Cricket Australia, they announced the Border-Gavaskar Trophy will be played as a 5-test series. So the Border-Gavaskar Trophy, it will be played as a 5-test series. This was announced. For the first time since 1991 to 1992, Australia and India will compete across a 5-test series this summer. Next is an update with respect to Women's Asia Cup 2024. The Asian Cricket Council, it has announced the upcoming Women's Asia Cup 2024, scheduled to take place in Dambulla, Sri Lanka from 19th of July to July 28th, 2024. The tournament will feature 8 teams, one more than the previous edition in 2022. India, Pakistan, Sri Lanka, and Bangladesh, they will be joined by the semi-finalists of the Women's Premier Cup 2024. These are UAE, Malaysia, Nepal, and Thailand. Indian diplomat Abhay Thakur is appointed as the new envoy to Myanmar. Senior Indian diplomat Abhay Thakur, he has been appointed as the country's next ambassador or top envoy to Myanmar. He is a 1992 batch IFS officer. He is currently working as an officer on special duty in the Ministry of External Affairs. Army deploys advanced anti-drone defense system along China border. So in order to strengthen its northern border with China, domestically developed integrated drone detection and interdiction systems, it has been installed by India. The escalating tension along the northern border with China, in view of this, the Indian Army has initiated significant enhancements to its air defense capabilities. And central to this strategic maneuver, it is the deployment of cutting-edge IDDNIS, which is the development of this integrated drone detection and interdiction system. This is developed domestically in collaboration of these two agencies. One is the DRDO, which is the Defense Research and Development Organization, and another being Bharat Electronics. DGNIA, it is appointed. The Ministry of Home Affairs, it is appointed Sadanand Vasant Datte, who is an IPS officer of the Maharashtra cadre of the 1990 batch, as the new DG of NIA. Now let's talk about National Investigation Agency. I'm sure you must have heard about this agency on a couple of occasions, especially a lot of legal news do pop up with respect to this agency. So the real name here is National Investigation Agency. It was established under this Act of 2008, which is the National Investigation Agency Act. This is the central agency to investigate and prosecute crimes in the following category. What sort of crimes are prosecuted by this agency? Offenses affecting the sovereignty, security and integrity of India, security of the state, friendly relations with foreign states. Apart from this, offenses against nuclear and nuclear installations, smuggling of high-quality counterfeit Indian currency. The NIA enforces international treaties, agreements, conventions, and resolutions of the United Nations, its agencies, and other international organizations. ASI begins excavation in MP to find India's oldest temple. The Archaeological Survey of India, it is excavating two mounds in Nachni village, which is located in Panna district of Madhya Pradesh. The goal of these excavation, it is to uncover what could potentially be the oldest temple in India. The excavation sites, they are situated just 30 meters from two ancient temples, a Gupta era Parvati temple and a Chaumuknath temple, which is built by the Kalachuri dynasty. These temples, known as the Nachna Hindu temples, they are among the earliest surviving stone temples in central India, alongside those found in the Bumara and Deoghar. This update is important. You may make a note of all of these names and just make a mental note of it, because especially in MP, they do often ask in their GK portion, questions on the art and culture of the state, the geography, the temples, and all of these. Now let's talk about Archaeological Survey of India. So Archaeological Survey of India, or ASI, it is an attached agency of the Ministry of Culture of Government of India. It engages in archaeological research and conservation, protection and preservation of ancient monuments and archaeological sites in the country. It regulates all archaeological activities which are conducted in our country through the provisions of a 1958 Act. What is that Act? Ancient Monuments and Archaeological Sites and Remains Act. It also regulates the Antiquities and Art Treasure Act of 1972. Also, please note, Alexander Cunningham, he is also known as the father of Indian archaeology. This is an important point. You may make a note of it. Now, this has brought us to the legal segment for today. So let's first talk about this update from the Karnataka High Court. So the Karnataka High Court has made it clear that it is only the husband or wife who marries for the second time during the subsistence of an earlier marriage and the lifetime of the earlier spouse, who can be prosecuted under Section 494 of the IPC. A single bench of the High Court added that the second spouse or their parents, they cannot be prosecuted under this particular provision. The apex court said that having a husband or a wife living, that is, if you have a living spouse and marrying during the lifetime of such spouse, then it shall be punished with imprisonment, which can be of either description, simple or rigorous, for a term which may extend to 7 years. This is the provision of Section 494 IPC. The court considered that in terms of Section 494 IPC, it is only the person who marries during the subsistence and the lifetime of the earlier spouse and the earlier marriage could be prosecuted and punished for the offences punishable under this IPC. The said provision does not even contemplate the person to whom the husband or wife is married for the second time to be prosecuted under Section 494 IPC. And with this, we come to an end of our TNA. In case you want to get access to the free study material that LawSikho curates or the TNA slides that have been used in this video, please feel free to join our Telegram channel. And for doing so, you may click on the link which is given in the description or scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us.